Okay, we'll begin. Good afternoon again, everybody. My name is Tassisius Kabutaulaka from the Center for Pacific Island Studies. And on behalf of CIPIS and the Institute of Sustainability and Resilience here at the University of Hawaii at Manoa, I'd like to welcome all of you to today's webinar seminar, which is part of our series called The Resilient Pacific. A couple of things before I introduce our speaker. The first thing is, please note that this is recorded and it will be streamed on the CIPIS YouTube channel later on. So those of you who are joining us, if you want to watch it later on, please visit the Center for Pacific Islands YouTube. The second is that, you know, the recording is only for the speaker and the facilitators. So those of you joining us are not part of that recording. The second housekeeping issue is that, you know, if you have questions, we ask that you posted it in the Q&A folder rather than on the chat. That way it's easier to follow at the end. So please, if you have questions, don't put it in the chat because that becomes really difficult later on. This afternoon, we are really privileged and thankful that Jacinta Ruru has agreed to present for our seminar series. Jacinta is a well-known award-winning professor of law at the University of Otago in New Zealand and co-director of the Ngā Pae Te Māramatanga, New Zealand Centre for Māori Research Excellence, a fellow of the Royal Society Te Apārangi, and recipient of the New Zealand's Prime Minister's Supreme Award for Excellence in Tertiary Teaching. In 2019, she received an inaugural University of Otago Sesquicentennial Distinguished Chair. Her extensive research considers Indigenous people's rights, interests, and responsibilities to own and care for the land. And I think this is a very important and interesting topic, legal rights of nature in Aotearoa, New Zealand. So thank you so much, Jacinta, for agreeing to be part of this, and we look forward to listening to you. I'll give it up to you now.
Oh, so in my language, tēnā koutou katoa ngā mihi nui kia koutou. Thank you so much for this opportunity. I'm really honoured and privileged to be able to sit with you here today. I wish I was there in person. It's quite unusual sitting here, obviously, and essentially just talking to my computer and looking at myself. It's a little bit unnerving, but bear with me. I am really thrilled to be here, and again, thank you for this opportunity. So I've been asked to speak for about 40 minutes, so I will try to keep to that and to ensure that we've got a good opportunity to do that Q&A at the end. So it's an enormous honour to have this opportunity to sit with you all today, even if it is remotely. And I thank you and welcome this chance to share and dream for just futures, where we all, including Indigenous peoples and our ancestors, can be clearly seen, known and heard, and where we listen, care and act So I'm here proudly as part of the University of Otago, down here in the South Island of New Zealand. We're very fortunate to be COVID-free at the moment in the community, so realise sitting in a very privileged situation in that context. We're moving into summer, so the sun's shining in, and we had a light sprinkling of snow on our mountains and hills overnight, so it's all looking very pretty. But I'm sure it's glorious there in Hawaii, and as I said, I so wish that I was there with you. The University of Otago is a partner to Ngā Pae o te Māramatanga, New Zealand's Māori Centre of Research Excellence. So some of you may very well have interacted with Ngā Pae, being part of our conference. We've got a big international Indigenous research conference next month. It's going to be 3 days online of Indigenous research excellence. Highly encourage you to think about registering and joining us for that conference. So Ngā Pae o te Māramatanga values at its heart mātauranga Māori, and at its simplest, that means Māori knowledge or Māori designed solutions for the nation. With 18 years of production of interdisciplinary Māori research, hundreds of Māori principal investigators and hundreds of Māori postgraduate students, hundreds of Māori engaged communities from all over the country, this is a home for Māori researchers, and it's a necessary home in an often adverse tertiary workforce where Māori, at just 5% of the workforce, can be swamped and isolated. We seek partnerships, and last week on Friday we learnt we won 37 million to continue our research, so we're hugely excited by that, giving us certainty for our operation through until 2028. So as I said, we're always looking for partnerships. I know we've already got some really strong relationships in Hawaii, but just extending again that offer of partnering with our Māori researchers, particularly in the sustainability context. We would love to see where that might go in the future. So Ngā Pae o te Māramatanga has been a big dream that was made possible by the likes of Professor Linda Tuhiwai-Smith. Back in the early 2000s. And that's one dream coming into life. And today's talk is similarly filled with aspirations. I'm trying to turn my slide, and it was working before. And I'm now not able to move my, I wonder if I do that. Work? Okay, no, if I can manually do it down there clicking. No, I'm all good.
It's
Sorry about that.
Is it okay?
All good?
Okay.
Kia ora. So in turning to the detail of this talk, I applaud and honour the intellectualism, bravery and resilience of our Indigenous ancestors and relations, then and now. And I ask these three questions. If we see and hear as a nation Māori environmental ancestors, and I'll talk more about this in my talk today. So if we as a nation see and hear Māori environmental ancestors, what do we do in response? A second question, if our colonial dominated current constitutional orders are no longer fit for purpose, what better orders do we dream for? And third, how do we seek to make right the rules of our country to enable well-being into the future? So I'm hoping to touch on those three questions throughout my talk today. And it is in this domain that I argue that the discipline of law matters. And I'm not sure how many in the room on this webinar are legally trained, but you'll see that as a law professor, I am going to talk a little bit about the law, and hopefully this is going to make sense to you all. So I argue that the discipline of law matters, and by doing so, in part, I believe, lies one of our greatest opportunities for positive transformation, to wish for and then make real the principles for our future. So let me share a little of my story before I get into the content. My father grew up in his father's tribal lands of Raukawa. So if we're looking here, we're looking at the North Island, and just in the middle upper part, you'll see, if you're looking at it closely, you can see just over to the side where you see the Tainui waka name there, you see Raukawa. So my father grew up in his tribal lands of Raukawa, next door to the humble family Paparamu Marae, bookended by his mother's peoples, my grandmother's peoples, the Umspis of Ngāti Ranginui and Ngāti Maniapoto. My Pākehā European mother grew up to the west of my dad in her beloved city, New Plymouth, where her ancestors arrived a generation ago. Her and mine ancestors arrived a generation ago. So I grew up in the far south at the head of Lake Wakatipu. So we're in the South Island of New Zealand. If you know the South Island of New Zealand, there's that big Southern Alps, that big mountain range that goes along the South Island. And I'm really at the southern bottom end, and over to the west side of the South Island. So I grew up in the far south at the head of Lake Wakatipu, in the remote Glenorchy, at the foot of the majestic Mount Hounslow, the braided waters of the Dart River, surrounded by lands protected in the Renown Fiordland and Mount Aspiring National Parks, managed by the government, the Department of Conservation, a government department that manages 1/3 of the country's land for conservation purposes. So 1/3 of Aotearoa New Zealand is locked up in the conservation estate. So to me, something seemed terribly amiss and remiss. Wasn't I also living in the lands of Ngaitahu, at the head of a sleeping giant? That's our stories for the Ngaitahu stories for Lake Wakatipu, as a sleeping giant on the boat of Maui, who we say used to catch the big fish that the Europeans named the North Island. Wasn't I living near to the trails of the most precious traded resource in the Māori economy, Greenstone or Pounamu, a place deep with centuries of Māori history and knowledge? But none of this was visually evident in the mostly overlaid English place names of my home. This childhood unease led me on to dream for better, more respectful ways to acknowledge Indigenous peoples' histories, stories, and interests, to remain stewards of lands and waters essential to our cultural identity and survival. And I ended up in the study of law. Law hasn't been kind to Indigenous peoples. It has silenced, stolen, and criminalised much of what is dear to us as Indigenous peoples. The discipline of law, though, took hold of me in the mid-1990s. It was a chance encounter. It was not always obvious. I would go to university, few we knew had, and I had been really inspired in my early childhood education. This changed for me in my 5th form, which we now call year 11. So I'm not sure how that translates into the American system, but essentially when I was about aged 15, when I read for the first time stories by a Māori author about racism in our country. Aotearoa's story, The Yellow Brick Road, was a change moment for me. Here was a story about a Māori family on a road trip. Now remember, I was brought up a long way away from my father's tribal lands, and we too would do these big road trips, up the country. Here was a story that for the first time made sense to me, that I was reading, and it was a big change moment for me. Here we have a story where a family are moving from a rural area into the city, and their car breaks down. They need more petrol, and nobody stops to help them in this kind of foreign urban setting. So I knew then I would go to university because I wanted to know more. I thought then my career would be in documentary making to better understand colonial injustice in our society. But once I began the study of law, I was hooked. I liked how I could build an argument to support a case to be heard in a forum that had to seriously consider it, the courts. But I struggled with much of the curriculum. It was a perplexing place to sit in lecture theatres. And those of you that might have legal training might know what I'm talking about here, but learning about like legal positivism, primary rules and secondary rules, clear cases and hard cases, all containing underlying messages that law is objective and just. I learned that this is our legal system. This is our current legal system, actually, which in some ways we're quite proud of. You can see the amazing lineup of women there as our top leaders. We still have the Queen of England as our head of state of Aotearoa New Zealand. Next in line is our Governor General, so our Queen's representative here in the country. Next we have our Prime Minister, Jacinta Ruru, and to the far there is our new Chief Justice of our Supreme Court, our top court. So while the people were different, when I was learning law, the structure was the same. I learned about our 3 branches of government and how government operates here in Aotearoa, New Zealand: Parliament, the executive and the courts. So we read the words of Parliament enshrined in legislation and the words of judges enshrined in court decisions. We were told as students that these were neutral words applied and interpreted neutrally by the courts. But I could not reconcile this unbiased standard of law with the stories my father's family told. These stories are about dispossession from ancestral land from the 1860s onwards, through insidious, racist, assimilationist legislation and local government rules. I knew our experiences were not unique. All Māori families tell of similar accounts. These experiences in my tertiary education and in all my formal education were mostly invisible. Studying law gave me an insight into how the law was used to achieve colonial goals. It did not convince me that law operates on an unbiased and neutral terrain. And so I came to regard the subject of law as both shocking and fascinating. Hundreds of years ago, the Europeans dreamed up their desire to expand their empires across salt waters. They developed a new legal doctrine, the Doctrine of Discovery. It holds that European countries can gain sovereignty of another's land on the basis of first discovery, even if other people live there. And this is one of the greatest examples of the magic of Western law. The Europeans made up a law to suit their desire to expand their control of the world order. It happened then, and it still happens now. The colonialist rules have been established to empower the colonialists. If law is this powerful, and if law can do anything, what now do we want it to do? And by knowing that law is biased, we have agency to make real our dreams in both a practical and constitutional manner. And this is what excites me, with our government now creating new law in recognition of a harsh history of breaching our Treaty of Waitangi, Tertiary Teaching, a document signed by Māori leaders and the British Crown back in 1840. In more recent years, in about 20 years of modern reconciling law, and at the tail end of historical apologies, we now have 2 national laws that recognise Indigenous ancestors as legal persons, and with more on the horizon to come. So we have the Te Urewera Act of 2014 and the Te Awatupua Whanganui River Claims Settlement Act of 2017, the recognition of a large forest area having legal personality, and our 3rd longest river, the Whanganui River, being a legal person. So for Māori, the first peoples to discover and make these lands their home, these places have always had personality, sitting in the world between Earth Mother and Sky Father. It is extraordinary that our state legal system has now recognised this too. Māori families across the country have dreamed of and fought hard for our country today to better recognise Māori relationships with lands and waters. My research argues that colonial countries such as New Zealand should more meaningfully connect with Indigenous peoples, and one way to do this is to reconsider the Crown's assumptions of having to own and manage public lands and waters. And legal personality is a vibrant, real way to do just this. Throughout the world, governments have the opportunity to use legal personality of the environment to address centuries of legal and societal racism and bias. Recognising nature as legal persons enables many powerful things for us as a country. Legal personality transforms our nation's legal system by placing at the forefront our society a Māori understanding of all that is around us. And in the words of our then Minister of Māori Affairs, when the Te Urewera Act was being, when it passed through our Parliament, our House of Representatives, our top government level of decision making, our then Minister of Māori Affairs, the Honourable Sir Peter Sharple, said, legal personality offers us, and I'm quoting now, the profound alternative to the human presumption of sovereignty over the natural world. So it is remarkable that our country has recognised a forest, a river, and soon to be a mountain as legal persons. This is something I never thought would have happened, despite arguing in my research it was possible. So if our country can do this, any country can. So what is this legal personality? And it's hard to gauge over the webinar how much you know. You probably know a lot, so bear with me. I'll talk for a moment about legal personality. What is this legal personality? As persons, we have rights and powers. In law, we're known as natural persons. Other entities can also have legal personality, for example, incorporated companies. What is remarkable with the recognition of a once national park and a still long river is that legal personality has extended to the environment. In a Western context, the American professor, Professor Christopher Stone, had a vision for environmental legal personhood back in 1972. He wrote a book titled, Should Trees Have Standing? And answered that question by telling us that trees, oceans, animals, and the environment as a whole should be bestowed with legal rules and a legal voice so they could be heard in the courts. But in Te Urewera, that national park, and the Whanganui River, they didn't become legal persons to simply protect those places. The law was already providing layers of environmental protection against degradation. For example, Te Urewera had been a national park. This is the highest level of environmental protection possible in our legal system. A national park must be preserved in perpetuity in a natural state. So the legal personhood of Te Urewera and the face of the Whanganui River are solutions born from the heartache and struggle to survive from an onslaught of European colonisation, where the colonial atrocities of warfare, destruction, and land confiscation have seeped deep, leaving societies in disarray. The Te Urewera Act of 2014 is perhaps one of the most beautifully written statutes ever. And while I do not routinely encourage the reading of legislation for joy, especially to a non-legal audience, this is one exception. So I'm going to read a small part of the Te Urewera Act. It's from one of the sections. And so this is to give you a sense of the language of this act. It writes, Te Urewera is ancient and enduring, a fortress of nature alive with history. Its scenery is abundant with mystery, adventure, and remote beauty. Te Urewera is a place of spiritual value, with its own authority and life force. Te Urewera has an identity in and of itself, inspiring people to commit to its care. And for the Māori tribal federation of this place, Tūhoe, Te Urewera is the heart of the great fish that Maui caught. Maui being our demigod who fished up the North Island of Aotearoa, New Zealand. And the legislation also recognises it is a place that is prized by all New Zealanders. So, moving away from directly quoting the Te Urewera Act, I think legal personality offers us the power to displace and disrupt racism in our society and in our state laws. In Aotearoa New Zealand, legal personhood makes sense because it aligns with the Indigenous Māori worldview and quite helpfully neutralises the hotly contested issue of who owns publicly regarded lands and waters. In practice, the opening words of the plan, so this is Te Kawa or Te Urewera. So if you think of a national park has a management plan. Because Te Urewera is being removed from the national park estate, it's no longer a national park. It is now Te Urewera. It is its own being. There is still the requirement by law that there is some written down rules for how one's going to care for this place. And so the Tūhoe, the Māori tribe or federation of this place, has named this Te Kawa or Te Urewera, so the rules of Te Urewera. The opening words of the plan begin, and I'm quoting again, and I think this particular document is one of the best written English pieces of work in the world. I'm very taken by it. I'm only going to read you three sentences from it. So the opening words of the plan begins, deliberatively, we are resetting our human relationships and behaviour towards nature. Our disconnection from Te Urewera has changed our humanness. We wish for its return. And I think that's really profound. It's a very powerful dream. I've been teaching and researching law for 20 years. I and many others have consistently urged legislative reform of our government's assumptions of owning and managing lands and waters, including national parks and rivers. While I dreamed for radical legislative reform, we are now at the significant juncture. The Te Urewera Act of 2014 and the Te Awa Tupua Whanganui River Claims Settlement Act of 2017 makes me immensely proud to be a New Zealander. A Māori way of understanding, caring for, nourishing land and water now has legal force. The national story of discovery and naming our lands has been seriously disrupted. There's more to these places than a European Western perspective. And the tool of legal personality, as used in New Zealand, shows us this. Legal personality of the environment shows us another way of understanding nature. The experience in Aotearoa New Zealand shows us, if we listen hard to Indigenous peoples, they too have ideas and solutions for us all in how to care for place. The idea here of legal personality, I believe, is one of our greatest hopes around the world to build bridges to the Indigenous worldviews of the personified landscape. It's not the only answer. It is problematic. It simply represents the best that could be negotiated within a realm that won't easily engage in restitution negotiation with recognition of continuing Māori sovereignty. What matters with our treaty settlements is what we do with these new enabled platforms. That's a role for us if we're all serious about reconciliation. To act is the most important thing. So if we see environmental ancestors in law, what more can we do? And so maybe just in the next 8 minutes or so, I want to share what our next dream is of working in a legal system that takes seriously Māori law. This work has been funded by the Boren Foundation, a foundation here within New Zealand. And I'm going to move through this a bit quicker, but I'm sharing it with you to show that we are still on a journey here in Aotearoa New Zealand. There is still much to do, and we're very much at the beginning of recognising and respecting Māori and Māori law. So what do we do in response? And often I ask, if we now see our environmental ancestors, so if our state law is now able to recognise from a Māori perspective our personified landscape, our mountains being our ancestors, our waterways being us, and who we are. So the health and well-being of our waters directly impacts on the health and well-being of Māori families throughout the country. So if our law is now beginning to see and understand that, what more can we do in response? And particularly because my field is law, I'm interested in what more can we do in the legal system. So, and particularly part of this is asking what role is there for Māori law to be taught as part of our LLB degree, our law degree. So this is work that a number of us have been involved in, and I don't know if you've ever come across the hugely charismatic Justice Joe Williams, our first Māori to sit on our top appeal court, our Supreme Court. And over a number of years, he, along with many others, have been writing in a similar vein, and essentially, particularly coming from Joe Williams, is the recognition that here in Aotearoa New Zealand, we have our Māori law, or our Kupe law, the law that Kupe brought with him on those waka, on those boats, hundreds and hundreds and hundreds of years here to the shores of Aotearoa. There was a legal system that developed and that was made sense here in New Zealand. That's our Māori law. Then we have Captain Cook arriving, and he too, with his peoples, brought a legal system that has been adapted to make sense here for New Zealand. We believe our next, big challenge for us is to really think about these two streams of law as being equal, of equal value, and what does that now mean to make our new law, our modern law, our Aotearoa New Zealand law, in recognition of these two streams of law. As part of this, we're trying to have visioning, and I know that I realise I'm not speaking to a legal audience as such, but we're going around and we're asking many like law firms and even just people in society generally. Earlier this week, I spoke to a group of elderly retired people from the community, about 100 people in the room, and asked them, what if they had their grandchildren going through university study now, what would they expect? So what does your dream graduate know from a Te Ao Māori, a Māori world perspective? What are the expectations of society around how we teach and know about Māori and Māori law? There's a lot of inspiration, including, around the world, including in America, Canada, and Australia, around how they are confronting this same issue and seeking to make significant shifts and change in a tertiary context around recognising Indigenous laws as part of the teaching. And we're greatly inspired by this work. Just a little bit of context. In New Zealand, Aotearoa New Zealand, Māori law graduates, there's a joke really, that there might be, too many lawyers in society, and we would sort of counter that and say there's certainly not too many Māori lawyers. We still need more Māori lawyers, more Māori graduating with law degrees are still, as you can see there, just very roughly on these graphs, a great disparity there. Recognising as a population, Māori at around 15-16% of the population, and a greater cohort in that youth context. So we've got 6 law schools in Aotearoa, New Zealand. Again, this is one of our visioning exercises. What would be the dream law school experience in learning Māori law? I've been great, some of the responses we've had from that. And then really this is our dream as Māori law academics across the country. This is what we are dreaming for, a bicultural, bilingual, bijural legal system, meaning that in a bicultural context, we are asking for recruitment and retention of Māori staff, recognising that law schools have usually just 1 or 2 Māori staff on their law faculties, which is totally wrong. It creates a very isolated experience for our Māori staff. Shared decision-making, financial support, and so on. From a bilingual perspective, Māori, Te Reo Māori, the Māori language, has been recognised as an official language of New Zealand since the 1980s. And while there's been some enormous gains made in terms of trying to recover our language, and particularly at a preschool and a primary school level, trying to teach in Te Reo Māori, we want also to have the right to be able to teach and learn law, state law, or the LLB degree in our Māori language. And a bijural legal education. So this is the recognition of the 2 laws in Aotearoa New Zealand. And this is really speaking to this responsibility that we have as a country if we are recognising our ancestors in law, our Māori ancestors in law, as beholding the responsibilities and our responsibilities to be with the environment, to be one with the environment, to care for the environment. That's got to filter through and influence our whole system. We need systemic change. And so sharing this little component of the LLB experience is trying to add and show the greater journey that is required here. And you can see here, speaking to the bijural, meaning the 2 legal traditions. And a little bit here on this PowerPoint slide speaks to some of our values from a Māori legal perspective. And that's really some of the questions that we're now asking around this opportunity. I won't pause there, I'll keep going. And we've just released a report on the Bowen Foundation website in August that's available to view and to see, and you can see in there our dreams. So that's, I think, bringing us through to about 40 minutes on, and I'll conclude here by really again just expressing my thanks for being able to sit here. And of course, while it's very odd, I'm really just speaking to myself. It's really hard to gauge who's listening, and particularly what you're interested in hearing more about. And so I think we've got a good time now for some questions and answers, which I really welcome. So kia ora, thank you once again for listening and being part of this. Kia ora.
Thank you so much, Jacinta, and thank you to our listeners. We'll open it up for questions. There is one, Noelani Gudia Kaupua has a question. So I'm going to read it out. She says, kia ora, Professor Ruru. Mahalo nui for sharing with us. And apologies for a long question. She says, I'm a fan of your work and have been reading and talking with my fellow Kanaka about the possibility of seeking legal personhood for Mauna Kea. I think you are familiar with the Mauna Kea issue here in Hawaii, which has been at the center of a huge struggle. One US attorney dissuaded some kia ai from legal personhood and towards a right of nature approach, saying that legal personhood opens the possibility of the Mauna itself being sued. Can you talk about the difference between legal personhood and rights of nature? That's the first question. The second one is, do you think it would be valuable for Kanaka Maoli to consider legal personhood for Mauna Kea while we are forced to live under US law? That's the second question. And the third one, any key lessons you think we should learn from the 3 different examples of legal personality in Aotearoa?
Right, thank you for that, acknowledgement and for those questions. So I have been a little bit resistant to the rights of nature paradigm. While I entirely agree with anything that is going to honour and protect our lands and waters and our trees, and certainly pragmatic about trying to use any tools that we can to ensure the visions of what Indigenous peoples wish for. To me personally, the rights of nature, or even the legal personhood concept, I see quite similar, not necessarily distinct, but that rights of nature, I see it as a continuing disconnect from an Indigenous perspective. The rights of nature tends to be simply a Western correlation of trying to make the environment similar to the rights and responsibilities, I suppose, as humans, as people. I think how we've used legal personality in New Zealand goes beyond that and cannot really be seen in a rights of nature context. So I see here in New Zealand how we've used legal personality is not from an environmental debate to try and protect areas, recognising, particularly with Te Urewera, it was already being environmentally protected. What legal personality has done in New Zealand is simply it's more than simply, but it has recognised a Māori way of understanding the world. And with that, that enables the displacing of that Western or the New Zealand government's presumption that they know best on how to care for a place. And so it starts us to move into a Māori way of viewing the world. It normalises that, and therefore a Māori way of caring for that particular place. And through that caring, it has to prioritise Māori laws, Māori practices and Māori values for how to care and know that place. And that has to become the priority. So that's where I see the great hope. And that's why I'm really excited by legal personality in that Aotearoa New Zealand context. And so how it's being used in the US or in Hawaii there more specifically, I would hope that it would be coming from a place where as Indigenous peoples can have their way of knowing the place and their way of knowing how to address a harm to the place and to the people, taking priority, and then whatever the law does, the state law does, and behind that to enable that greater visioning, that is great, whatever tool is being used. So I'm not sure if I've really answered that. The difference between legal personhood and rights of nature essentially just comes down to the intent. What is the intent that you are trying to create here, and whose laws and values are you trying to prioritize here? Or is it just being used as another environmental tool within that Western legal sense of law? Is it not really going beyond that in any way? You can see that I'm really, I'm very taken with legal tools that can be used to get what Indigenous peoples want. And I see law as being able to be dreamed up to be able to be manipulated. So I can see it as being, the law should be the values of us as society. And so law needs to change. And while law has done, the Europeans have used law to their advantage and making up all that magic of law around discovery and so on. Well, we need to take control of that from an Indigenous perspective, and again, use law to know that law can change and that law is biased, and let's make the bias now in favour of us and creating the tools that we need to be able to manage it and care for and know a place. So I see the strength of legal personality in being able to disrupt normal conversations around environmentalism, and to start from a different place of knowing, okay, these waters, how do we know and understand these waters? From a Western perspective, they can think about waters as being a boundary line, to certain points and certain, on the riverside or to the midpoint of the river, and certain neighbouring properties have certain rights to certain parts. That's kind of a Western way of seeing and dividing up land. An Indigenous way of understanding and knowing land is very different, and that's what I would hope would be disrupted there. The point about being sued. Yes, it can be sued. Yes, that's what comes from having legal personality. But then you can think about what are the protections that sit around that to enable some protection around that. So, Shorter, thank you for that question.
Thank you, Jacinta. We'll come back to some of those issues later on, but
yeah, there's lots there.
Yeah, there's a question from Joshua Cooper from UH and Hawaii Institute of Human Rights, and he says, aloha, great presentation. Really appreciate hearing about the two laws in 2014 and 2017. Can you please share the mechanisms created to ensure the rights enshrined in the laws?
Yeah, so the innovation in these settlements and these new laws really comes from prioritising that Māori worldview. That's the big innovation. When you actually look at, for example, the Te Urewera Act, so Te Urewera, remember, was that national park, and now it's itself, it's the heart of Maui, and the mechanisms around that now is a priority for Tūhoi to care for the place. And our Department of Conservation have, about 3 people, I think, out of a board of 9 who can sit and help to influence the management of the place as well. That Te Urewera Act has a lot of similarities to our National Park Act. So, like I showed you, Te Kawa o Te Urewera. So there's still a requirement in law for Te Urewera to have a management plan. And Tūhoi have called that now something else, but there's still a requirement for that. There's still a requirement that public have access to the place. There's still a requirement, for the appropriate management of that place, and that you can't just do what you like in that place. So it's still regulated by our state laws. And so if you could look at that Te Urewera Act and think, well, actually, how is it different to our how is it different to a concept of co-management? How is it different? It just looks like you're just putting, some Māori onto the decision-making board and so on. And that would be a fair enough critique, but I believe it's more than that. And I think it is this displacement of the place being beautiful just for its scenery and therefore required as part of our conservation estate. It's more than that. It's the heart of Maui, and knowing that as the starting point completely changes everyone's relationships with that place and therefore changes the discussions. So the mechanisms can look quite similar to existing law. That's different to the Whanganui River, and the Whanganui River is much more difficult. It's our third longest river. It goes through different like government territorial boundaries, it's sort of from the mountains out to the sea. It's got hydroelectricity dams on it. Our farmers are relying on it for irrigation. There are commercial companies, polluting into the water. So working out what legal personality of recognising that that's an ancestor, that river, and how we care and know for that, and balancing those commercial interests is really tricky, and it's much, much harder than how you care for a defined area of land, which is Te Urewera. So we're still as a country working at that out, and the iwi, or the tribe of that Whanganui River, also need to be given the time to be able to work out how to do this.
So here's a question that relates to a question that Noelani raised earlier on, the issue about these entities or rivers or nature being sued as a result of their legal personhood. If say a river were to be sued, who is actually being sued in terms of, is it the custodians of that river or the state? Or I was wondering if you could comment on that.
Yeah, so you can think of a context of where a river could be sued, like it could flood and damage people's properties, for example. That could be perhaps an example. I'm just trying to think back into the law, what it does around this. Is it the custodians, or they're the people who speak on behalf of the river? I'd have to come back to you. I should have actually prepared for this, knowing it, because that suing isn't really part of the New Zealand kind of makeup, but it is part of the US makeup. So I should have prepared for this. I should have known this question was coming. And I'm going to have a quick look afterwards, even maybe as
that's fine. That's fine. You're absolutely right. Here in the US, it's a big issue that people are concerned about. There's a question from Kealoha Mossman. Said, amazing presentation. Mahalo for all your hard work in creating new grounds for legal representation for our Aina and sharing with us.
Thank you.
I think what makes it hard for to apply such concept here, meaning here in Hawaii, is the US, is the perception of environment versus economy. People don't want to protect lands due to the thought of losing money. My question is, how do we go about changing the perception of the masses to better see the value of nature, not a consumer sense, but in an environmental service sense?
Yeah, so I totally understand this question. Thank you. And I never thought that New Zealand would have done this either. And I would have thought that it was something impossible for us as a country to do. So how do we go about changing the perception of the masses? That's the big question. And that's about maybe the win-win of this, around how much we can gain from recognizing a place as being important for what it is, rather than our value, our human kind of value from it. If we can speak about our environment around it and the health and well-being of that environment being directly impacted on the health and well-being of the people. If your environment is flourishing, your people can be flourishing. And somehow we know that evidence would suggest that and show us that on many different levels from a well-being perspective. Being able to fish and gather from the water, which then enables families to come together, which enables the sharing of knowledge, of being able to sit together, which then also enables commercial activity. You know, if everything is working well and everyone is well, we should also have the commercial economy should also be part of that. But when we have, you know, one part significant, or two parts really significantly broken, when we have the environment and the people unwell, and only just focusing in on the economic side of it, you know, it's just not going to work in the long run. And so how can we break through that and find ways that is a win-win? And something like legal personhood can perhaps sometimes just be used in that kind of symbolic manner to change up some of the discussion and the starting point of how to know this place. So for example, Te Uruwera, look, I wouldn't have thought this would have been possible in New Zealand. Te Uruwera, that national park, was meant to be returned to Tūhoe, the ownership of that national park. And the government was really on the brink of doing so in a major settlement, and really on the night beforehand, our then Prime Minister John Key said, essentially no way, and made some quite disparaging comments about that tribal entity. And it was a real low point for us, and thought, gosh, it's just never going to happen. You know, how on earth could this happen? And then there was this breakthrough of using this legal personality. And when that happened in 2014, New Zealanders didn't know about it. It wasn't something that was celebrated in New Zealand. There was no big fuss made about it. And New Zealanders, I don't think, even became aware of it really, as generally, like in the media and so on, until 2016, when a New York Times article wrote about how amazing New Zealand is. And New Zealand's always trying to, what we call, get on the map and be noticed. And, you know, and so this New York Times and The Guardian, writing in a really positive way about what had happened in New Zealand, made New Zealanders proud. And also 2 years had passed since then, and like the sky hadn't fallen in. People, you know, the world didn't change by recognising a Māori way of understanding that what was a national park and this huge area had been removed from a national park, you know, that we didn't have that whole breakdown of society. And I think time can heal and can also show us that as New Zealanders, generally, we can have a much, and our international visitors can have a much, much better experience of now walking through Te Uruwera now, when it is being cared for appropriately. Everyone is proud of that place, not just one group of people. And so it's trying to get our commercial, economic component of society into recognising the win-win well-being for us all. And I know it's very difficult. And we have these ongoing struggles here in Aotearoa, New Zealand. Don't think that just by highlighting one or two examples that it's that we've got this answered here in New Zealand. We certainly don't.
Thank you, Jacinta. One final question from Samuel Pooley, or there's two more questions actually. And Samuel says, yours was a very nice presentation. My understanding is that Maori have special rights to oceanic fish, a share of quota in a Western fisheries management framework. How does the exercise of those rights by Maori relate to legal personality perspectives, or that's it?
Great question. So no, it doesn't relate in a legal personality concept, but it does from that starting point. So Māori, we do have Māori have a quota share of commercial fisheries and protected customary fisheries places as well. That came from our treaty settlements. And so Te Uruwera and the Whanganui River, that comes from our treaty settlements as well. This intent by the government to negotiate with Māori, a very small recognition of the wrongs done. So that's where that similarity comes from it. But in saying that, there is a greater movement that's taking place by Māori, and I think we're connecting in with like our Indigenous Pacific relations, including there in Hawaii, around talking about calling for that our Pacific Oceans to have legal personality. So I don't know if people in the room are aware of this. It's just quite new. We started it last year, here in Aotearoa, New Zealand, and it was our response to our country's big, actually they initially called it celebrations, but then they did rightfully call it commemorations of 250 years since Captain Cook landed here on our shores. So it was kind of as a response to that, and as here, many in New Zealand Māori were wanting to reframe those Tuia 250 commemorations into showcasing the greatness of Māori, you know, our intellectual abilities that enabled us to deliberately, you know, navigate those ocean waters and arrive purposely here on the shores of Aotearoa. So it's a very different kind of story that gets told to, you know, New Zealanders, and that how Māori just sort of accidentally arrived here, malnourished and starving and so on. So we wanted to tell a different story and about our greatness and our intellectualism that enabled that navigation. And through that kind of navigation through the Pacific and here to Aotearoa is a story that we're starting to generate around legal personality of the ocean. And this would need to be worked on with the Indigenous peoples in the Pacific as well, whether they want this or not, because it is a connected story of the Pacific and our personification of the place. But that idea that the ocean is us, we are the ocean. So the ocean is us, we are the ocean. And so that's kind of that narrative that we're really wanting to speak to in a very powerful way, and looking to how we might protect that. And imagine, you know, a legal personality tool in an international context, an international tool that recognises, like from a Māori perspective, it's Tangaroa, our god of the sea waters, you know, who is us, who we see and who we hear and care for. You know, imagine something like that would unite and connect us and would celebrate Pacific Indigenous peoples in a really positive, connected way, in a way to how we move forward in the future for caring for that beautiful ocean expanse that is us.
Thank you, Jacinta. Just a comment before we finish from Kealoha Mossman. Said, such an amazing story. The health of the land directly impacts our overall health, and great solutions are born from great resiliency. Mahalo nui for your answer, and we are all proud of Aotearoa and the mana you all carry. Mahalo.
Thank you.
We don't have any more questions, Jacinta. So I think our time is up. So, you know, I would like to finish by thanking. First, thank you to you, Professor Jacinta Ruru, for giving up time from your busy schedule to be part of this. We are really blessed and graced by the gift that you've brought to this series. So thank you so much to you. I also want to acknowledge my co-convener, Dr. McKenna Kaufman from Institute of Sustainability and Resilience here at UH Manoa. She's unable to join us today, but thank you to McKenna. And also thank you to two people who are, you know, behind the scene working to make sure that this works, because people like me don't know how the technology works. So thank you to Ida Arik and Dr. James Viennes. Ida is with ISR and James is with the Center for Pacific Island Studies. Thank you again to you, Jacinta, and thank you to all of you who have joined us for this session today. Thank you so much, and mahalo, bye.
Thank you everyone for this opportunity. It's wonderful to be able to share and connect in this way, and look forward to ongoing conversations. Thank you for all of your kindness and your greatness as well, and all of the research that you're doing. Kia ora, thank you.
Thank you, Jacinta.